So the surveillance recording played in court there showed some of the lead up and the surrounding situations to this shooting of this poor woman's husband, but it didn't show the shooting itself. So that's what we were promised yesterday during the opening statements in this case. Julie Rendelman's here along with me now. Julie, this process of getting a witness on the stand, off the stand to sort of go through a recording and then back on the stand is pretty typical.
Yeah, no, not unusual. I mean, obviously, there's more to hear, and I'm curious what, if anything, she's going to be able to say about the individuals that actually committed this crime, if she's going to be able to identify them.
Yeah, that's the key point. We had today with identification being certain or not certain. Let's go back to the testimony. We might be at the end of the testimony of this widow, Megan Price, who just described the attack which left her shot in the left leg and her husband dead. With me, Julie, this is one of those witnesses that if you're a defense attorney, if you choose to cross-examine this witness, you need to tread very lightly.
Well, actually, I agree with you, and I'm not sure you should even necessarily tread. She hasn't identified any of the individuals in the courtroom. And so the last thing I want to do is give her a chance to do just that. So if I were the defense attorneys, I would be more inclined not to ask her a single question. Yeah,
and a lot of defense attorneys get nervous about that. They're afraid to not ask any questions. But here, I think that this ended on a note that was beneficial for the defense. Look, everyone knows that this woman endured horrible pain herself, the loss of her husband, being shot right through the heart. He died on the ground next to her at this scene after they were out celebrating her birthday. And you can read not only the pain, but a sense of resolution in her voice, sometimes anger, which is understandable. But at the end, she did the honorable thing and said, I don't want to be responsible for making the wrong choice and identifying the wrong person. She can't directly identify these two defendants.
Yeah, I don't know if I want to call it the honorable thing. I mean,
well, she's being honest.
She's being honest.
Yeah, which is itself honorable compared to what we saw yesterday.
I hate to say it, but when we swear to tell the truth, we have an expectation to tell the truth. Unfortunately, we had an individual yesterday who had his own opinions about the color of the individual's skin that impacted his decision.
Well, we are going to have some cross-examination here, so let's cut back to court. Testimony there in the Jonathan Price murder trial, the case where a U.S. Marine was shot and killed in a parking lot with his wife by his side. That was the widow testifying about the attack that left herself injured and her husband dead in that lot. Julie, there was a double cross-examination there. We were wondering if it was going to get to that point. Again, two defendants, two attorneys. Each attorney gets a crack at cross-examination. How do you think it went?
I mean, look, there's not much to get from her other than that she can't ID. It sounds to me like she is, there were a couple things they were going after, one being that she describes at least one of the guns to be a silver gun, and so it's unclear whether or not the gun that was actually recovered that we believe to be the murder weapon is in fact silver or maybe black, so I assume we'll learn that soon enough. The next thing that they seem to have covered, which I think is relevant, is whether or not in a prior time she had indicated that the gun, that either both had guns or only one had gun. One, because it would be inconsistent with what she had testified or what she had stated earlier. And two, remember there's two separate defendants, and both not only looking at the potential for convictions, but also the potential for the death penalty. And so it is important for each defense attorney to distinguish the behavior and the actions of each of the two defendants if you accept that the jury finds one or both guilty. And so distinguishing their actions can have a big impact on what the jury's final decision is as well.
I mean, does it mean anything that she's testifying that they sort of approach from different directions among these cars in the parking lot, or does this just result in, hey, look, if somebody dies during the commission of a felony, then there's guilt to pass around all around?
I don't know the specific law in this state about felony. What specifically they must. Certainly prosecutors can argue that the reason they're coming from two different angles is because they're going to surround them, so that they're going to make sure they cut them off on the pass. You know, I think it is relevant, though, on top of everything, not just whether one gun, two guns, but also they did at least try to touch upon slightly indications about her inability not only to identify the people but to describe them. It was hard to hear because the cross, quite frankly, was difficult for us to hear, but to distinguish her ability, whether the individuals matched the description of the actual defendants that participated. If she had indicated in one of the situations that she wasn't sure a prior description and that description helped the defense, then certainly I'm surprised that they didn't actually present her with the documents that indicated she had said something differently to establish that she may have described the individuals differently than the two defendants that are on trial.
Well, I mean, she did give some basic identifiers here. One of the suspects was in his 20s, the other was in his 30s. That was a guess. She knew one was definitely older from the other. One was wearing a white T-shirt, the other was wearing a dark or a black shirt. One had dreadlocks, one had short hair. They both were about the same height, and she described their guns. She said, when asked to give a specific identification out of a photo lineup, she said she, quote, didn't want to be responsible for making the wrong choice.
Correct, but she also later made a different statement. She said something to the effect is that she chose not to do an identification, and maybe I misunderstood what she was saying.
In other words, I took it to mean that she declined to identify anyone in the lineup because she didn't want to make the wrong choice.
Which, I mean, I assume that she would have followed up with what she had said earlier. It is unusual, though, for that to be the testimony of an individual. And again, as we talked about before, as the defense counsel, you have to tread really lightly with regards to that because positive, even that's going to hurt the defense. So that's why I think they tried to stay away from it as best they could.
Exactly. Well, we're going to dip into some other things to talk about here on the Law and Crime Network. Just a reminder what's going on in the Wallace-Bradsher case. That's the case of bottom line official corruption. That's the allegation in that case in North Carolina. Wallace-Bradsher, a former district attorney who's facing official corruption charges in an alleged wife swap for employment purposes with a neighboring district attorney. In that case, jurors had a number of questions. Those questions got answered within the last half hour. Jurors are back deliberating. I just wanted to keep you up to speed on that case. If there's a verdict, we will bring it to you. And keep in mind, they're off tomorrow in the Wallace-Bradsher case. Does that mean it's possible jurors might try to push for a verdict today rather than push this case into next week? Sometimes that's what happens. But we've got another case we're following, the Bob millionaire was convicted not of murder but of a lesser charge. We're going to go there. He's being sentenced right now. A surprising sentence there in the Bob Ward case in Florida. Again, this we were calling the millionaire murder trial. It resulted in a manslaughter conviction, though, so what we used to call it is not exactly accurate at this point. We just watched sentencing. We got to it in the nick of time there in Florida. Bob Ward, a millionaire whose defense was that his wife was trying to kill herself and that the gun went off while he was trying to wrestle it away from her. Again, this defense involved a mix of weapons, prescriptions, and alcohol. That was the defense. The jury at least didn't buy it lock, stock, and barrel and wound up with a manslaughter conviction. The judge could have gone somewhere between 13 and 30 years, and the judge gave him the maximum allowable sentence under the law in that state.
Yeah, I mean, look, you know, in many of these state cases with the statute, the judge is allowed to, and I don't know the specifics in this case, the judge has a lot of leeway as to which way to go. She clearly, obviously, I'm willing to bet you thought that maybe there was a murder that he got away with, and so that she chose to go for the maximum. I'm a little surprised based on the evidence I heard, but it's the judge's prerogative to do that.
Yeah, now this was the case where the defendants and the victim's daughter, they were married, they had children together. The daughter was defending him, saying, no, my father didn't do this. There were a lot of pieces of evidence that tried to tie together whether the wife had depression, whether this medication that she was on could interact with alcohol and result in suicidal thoughts. It was a case that did bother me because when you start mixing these medications and when you have mental health suppositions going on underneath it, then one can't completely and fully really get in the mind of someone else.
Sure, but
and it resulted in a verdict that resulted in one of the children not completely flying off the handle, but coming close to it when the verdict came down.
Yeah, but I mean, at the end of the day, the jury heard everything that we're talking about, and the jury made a decision to, guilty of something. And we talk all the time about the idea of, did they kind of compromise by doing somewhere in the middle? I don't know. But remember, the first case, I believe, ended with a conviction for the murder. And so it was now, I believe, if I'm remembering this correctly, now we have a retrial where, I mean, obviously the defense did a better job, or at least the jury bought some of what they were selling. They just didn't buy it all.
Yeah, so now we have a conviction. That happened a while ago here on Law&Crime. We also have a sentence. You just heard that delivered. Bob Ward, a Florida millionaire who said that his wife was suicidal, had a gun, and that the gun went off accidentally. That was his defense. He was convicted of manslaughter, and now just moments ago here on Law&Crime was sentenced to the maximum 30 years for a manslaughter conviction related to his wife's death. We are in recess in the Jonathan Price case out of Kentucky. We're going to continue to monitor that courtroom after some gripping testimony from the victim's widow, who was on the stand describing the attack. We'll be back to that as soon as court is live. We're also continuing to monitor the Wallace-Bradsher case in case there's a verdict in North Carolina. A lot going on here on Law&Crime, and a lot going on lawandcrime.com. So let's get you caught up to date on some of the top crime stories making headlines today.
Here are today's top crime stories trending on lawandcrime.com and across the country.
More testimony from a detective in the Jonathan Price case out of Lexington, Kentucky, rather. This is the case where a U.S. Marine was shot and killed while he was out celebrating his wife's birthday. She was also injured in the attack. She testified this afternoon. Julie Rendelman, we've been of the opinion here, meaning you and I, that there are a lot of threads in this case that the prosecution is just not tying together as well as perhaps the prosecution would like.
Yeah, I mean, look, I mean, this is supposed to be a fairly lengthy trial, so, I mean, time will tell, but we right now have a situation where it seems clear that we don't have an identification of the individuals that actually did the shooting. And to me, that's a huge, huge, huge gap. Position in terms of proving these individuals guilty beyond a reasonable doubt. They may be able to prove that they did the robbery. The question is, can they bring that to this case and say, because they did that, they did this?
Yeah, let's go back to court. Got another witness coming in. Welcome back to Law&Crime, folks. It's the end of the day in the murder trial of victim Jonathan Price. He was a U.S. Marine corporal who was shot in the heart and killed as he was out celebrating his wife's birthday. His wife was also with him, and she was being robbed. He stepped in to try to defend her. Both of them were shot. The wife was shot in the leg. She survived, and she was on the stand earlier today. To help us break this down a little bit further, Julie Rendelman is with me. She's a criminal defense attorney here in New York, former prosecutor and Law&Crime trial analyst, a person with 3 titles, as she dislikes me.
Yes. No, I like
out.
You. I like you.
No, you dislike me pointing that out.
Yes.
Despite your accomplishments. So, look, to be one of identification. There has been an attempt to identify the 2 defendants who are facing murder charges and a possible death penalty here by asking someone else who was the victim of a separate incident at a hotel who attacked him there.
Right.
And he thinks they were, or at least one of the people who was attacked in that hotel room, thinks that they are, but he also admitted in Facebook.
Right.
And just to paraphrase what he said, he basically said in as many words that all blacks look alike, and it raises questions as to whether or not he's making an accurate identification.
It also raises questions about his credibility as a witness,
that too.
To the jury. I'm very curious to know the makeup of the jury in this case, just because, when we talk about the impact that some of his comments made, comments that were made by him outside of this courtroom that were brought up by the defense, the makeup can have an impact on how people take what was said. I mean, and also, quite frankly, just to go back to that, I am shocked that the defense didn't spend much more time cross-examining him, as well as one of the other male gentlemen that testified in regards to what seemed to be an incredibly weak identification of the individuals that are alleged to commit this crime.
I agree with you. You know, look, if you've got racist statements on Facebook and questionable identifications, you want to basically milk that for all it's worth as a defense attorney. You want to dig in a lot of attention to it, and it flew by in what felt like a millisecond.
It was a millisecond.
Yeah, the defense attorney put it up on the screen and then just said, "Did you make this statement?" Yes. And to whom were you referring? African Americans? And then she moved on. It's like, wait a minute, you got to pound that in.
You know, in every area, it seemed that the defense attorneys seemed almost insecure with their position as the defense attorneys in this case. And so, you know, they don't seem to be taking control of the courtroom, which is what you want, in a sense, to see. I think the one defense attorney, because there was two, one didn't give an opening, the other did. I think she did a fairly effective job in trying to hammer to the jury early on some of the weaknesses in the case. So I give her that. But I think that cross-examination is a time to pull jurors onto your side. And when you have a witness who identifies individuals in a photo array and isn't even confident that the individuals in the photo array are the people that committed this crime, and the next thing you know, the only identification really of these individuals is those that are sitting in the courtroom when everyone knows that they're the two individuals on trial for murder, I think that you have a lot to work with, and to leave it to the jury for their own imagination is concerning for me to sit there and not be able to jump in and want to cross-examine them myself.
Yeah, look, I mean, you want to, as a cross-examiner, sort of start with a postulate that everyone can agree upon, like, well, sir, if you were accused of a crime, you would want an identification of you to be accurate. You have to force them to agree on that.
Well, no, you have to.
And then,
no, I disagree with you there. That I disagree. That I disagree.
Then how do you do it?
I think the way you do it, first of all, is remember that this is, as we've talked about before, a crime of violence where the individuals are not staring at the faces of the individuals that robbed them. Many of them were put to the ground, and they don't have an opportunity to saying are responsible. And if they didn't have an opportunity to view their faces, then how in the world is the jury going to rely on them to say that they're the people that committed this crime?
Well, yeah, that's part of it.
That's the hugest thing is, can you identify
but you got to keep the questioning going. That's where I was going. I would have tried to stretch that out to make it last 20 minutes long.
I think my cross-examination would be much better than yours.
Well,
but you know.
Well, I know that you think you're perfect. But anyway, we have to wrap up for the day. It looks like the Wallace-Bradshaw case in North Carolina is getting out. Jury is still deliberating that official corruption case. So a reminder, folks, that we are on the air live from 9 a.m. until 5 p.m. Monday through Friday with live coverage of trials. This is Aaron Keller, and for everybody here at Law and Crime, have a good evening. We'll see you back here tomorrow.